Good morning for those of you who are just signing in now, and good morning to those of you who are watching the recording of today's presentation. We're going to begin formally in just another minute or so. All right. Well, good morning to those of you who are joining us live as well as by recording. And we are glad to have you here for the second of our four Aging with Grace sessions. Today, we are going to be focusing in on legal considerations when it comes to aging. And we have two more sessions coming up after this. Our third session will be on understanding living options, and our final session for our series this fall will be on paying for aging. One housekeeping reminder. Ordinarily, we would go in 4 subsequent weeks. After today's session, today is September 18th of 2023, we will take a break next week. I will be unavailable the following Monday, and we will resume our sessions on October 2nd and October 9th, respectively. So there's still time if you haven't signed up for those third and fourth sessions to go ahead and go to our website to hhci.org and to click on the events tab, just as you may have already done with our first session and with today's session, and sign up for that as well. Normally, we would have the same Zoom address for all of the sessions, but ultimately, because of that gap, we've needed to assign separate ones. And so I hope that won't stop anyone from navigating their way into our series. Whenever you find yourself here, we are glad to have you. For those who may not have been with us for the first session of the Fall 2023 Aging with Grace series, my name is Seth Stander, and I am the Community Aging Specialist for that part of the Hope and Healing Center and Institute known as HHCI CARES. HHCI, the acronyms for the Hope and Healing Center and Institute, and CARES, which stands for what we do in this division of HHCI. We focus on issues related to caregiving, aging, resilience, ethics, and spirituality. Again, if you go to our website, to hhci.org, you can click around and you can see not only information about our particular part of the Center Institute, but if you click perhaps on the Resources tab, you'll see previous recordings of programs such as Aging with Grace, but also having to do with the other elements of what makes up CARES. So CARES is directed by Dr. Peggy Dettermeyer, and she and I both offer consulting with special emphases on the hopes and challenges of aging, on bioethics, on the hopes and challenges of caregiving, and on navigating the journey of grief. We are pleased, thanks to generous underwriting and a robust philanthropic department, to be offering our program to you free of charge. So let's go ahead and move into our slide deck for this morning, having to do with legal considerations of aging. And to start, we do need to put a disclaimer in place. Neither Dr. Dettermeyer nor I are either attorneys in general or your attorneys specifically. So we want to remind you that this is an overview of legal estate options here in the state of Texas. you will want to consult with your own attorney, ideally an estate attorney, for specifics related to your own issues and to your own location, whether you are watching us while residing in Texas or while residing elsewhere. So let's begin with a fundamental question. Do you have a will or a trust? Now, if the answer to either or both of those is yes, that is terrific. A lot of what is contained in here is an explanation on what wills and trusts are and why they are important for you to go ahead and to create and maintain, all part of, to dovetail on our first session last week on healthcare rights and responsibilities, on the right to have wills and trusts created to benefit you and to inform those around you, but also your responsibility to go ahead and to produce these unless you are comfortable having an outside party do it for you, which is to say, and for the next few minutes, we're going to focus on wills, and then we'll get more to trusts, that if you don't have a will, you can rest assured, or as I put on the slide, no worries. The state of Texas has written one for you, and I've put in parentheses, yay, with a question mark, because again, there are provisions for people who die intestate, that is to say, without a will in place. Those details are located primarily in the Texas Estates Code, that lays out how your property will be distributed amongst your heirs. Now, the definition of heirs becomes rather formulaic as we move into what the state says is a just allocation of your estate, your assets. For example, and this is one of two slides that have to do with what is called intestate distribution. This is still current in the state of Texas. Obviously, if the laws change, we'll update these slides as we go along. The first few categories of this are relatively straightforward in the sense that if your heir is your spouse and there is no one else, no children, no siblings, no parents, ultimately your spouse in an intestate distribution situation is going to inherit the entirety of your estate. The same would apply if we substitute the term children for spouse. And again, it presumes no spouse, no parents, no siblings. And as you can see on our chart, if only parents and no spouses, children, or siblings, parents will receive everything after your death. And if only siblings are your heirs, as opposed to spouses, children, parents, they will receive everything that is yours after your death. Now, there are certainly situations where someone who dies intestate, lacking a will, can rely on the Texas Estates Code to go ahead and to make sure that their assets are safely transferred to this one specific type of party, be it spouse, children, parent, sibling. But that's usually not how families work, in the sense that very often you may have a spouse and children. So if we take a look at the grid that is dedicated to that category, you're going to see that because there is community property that needs to be distributed, it is going to be distributed in terms of 1/3 of the separate personal property that you own will go to your spouse. Your community property goes to your spouse, and the right to use the real estate, assuming you have a property that you call home, and that it is in your ownership, is going to go to your spouse. And the children will receive the other 2/3 of the separate personal property that you own. Having said that, what they choose to do with it is, of course, up to them after they have received either the assets or they have been liquidated in terms of their worth. If you have a spouse, but you have children who are not the children of that spouse, very often we have folks who remarry, and in that marriage, children are not produced in older age, but there may certainly be children from a first marriage. And ultimately, the state has said we want to do an equitable distribution. Since we lack a will, we're going to follow our intestate distribution guidelines, which means that half of the community property is going to go to your spouse and to your children who are not the children of that spouse. A third of the separate personal property and the right to use the real estate, as you can see, carries over formulaic from the spouse with children by that spouse. But you can also see that the other half of the community property, along with the other 2/3 of the separate personal property, is going to go to the children who are not children of the surviving spouse. And again, distributing all of that may take quite some time as inventories are tallied and ultimately fair distribution is put in place. Now, as I mentioned, this is simply a continuation of the formula we started on the previous slide. Let's say that you have a spouse and you have living parents. Intestate distribution declares that the spouse gets all community property, all separate personal property, and half of any separate real estate, which means the parents get the other half of the separate real estate. That's the term anything else in this particular formula that we see. What it also means is that potentially there may be an issue with regards to whether or not the spouse can remain or whether they have to go ahead and either buy out the other half of the separate real estate or be part of a sale that they may not be enthusiastic about and have to relocate. Because as you can see, compared to the previous slide, which I'm going to click back to, the right to use real estate is not included in this particular category. Another good reason why, when you are younger and you marry, it is still a good idea to go ahead and to have a simple will so as to avoid the additional heartache that might come from, whether it is by choice or out of financial need, parents stating that ultimately the real estate that you have dwelled in with your deceased spouse is going to arguably need to be sold, and all of the legal issues that surround that. When you're dealing with one parent and siblings, but you have no spouse, that is to say, you have died single, you have one living parent, you have siblings, half of the separate property goes to that parent, half of the separate property goes to the siblings. They have to figure out the best way to distribute that one half of remaining separate property that you used to own before your death. It can get a little messy depending on the relationship between your siblings and whether or not there are precious parts of that separate property that they consider to be family heirlooms or otherwise just have always coveted. It's not right or wrong in this particular case, but it can be messy. And then when we talk about no parents, but a spouse and siblings, you can see again all community and separate property, and half of the separate real estate goes to the spouse. The siblings get everything else, and it can be the same kind of relocation possibility for the surviving spouse, because again, it may be driven in such a way, financial need or personal desire, so that ultimately residing long term in the real estate that you and your now deceased spouse shared will be in question. So these are some terrific reasons just by themselves to go ahead and to form a. So let's talk about what the ultimate purpose of a will is. For those that have it, it's always good to refresh your memory as to why it's there in the first place, because ultimately, the reasons why you may have created it in an earlier stage of your adult life, the circumstances may change. Especially if you have children and they have aged into adulthood. First and foremost, though, distributing your property to your chosen recipients. Notice how I'm emphasizing your in both cases, because we're trying to go ahead and champion your autonomy when it comes to creating a will. And when it comes to who your chosen recipients are, they can be people, they can be organizations. For example, spouses, children, other relatives, non-relatives, charitable organizations, and the list goes on. I just wanted to give some representative examples as to different ways that people put people, other people, I should say, or organizations into their value system, which includes the legacy that your values continue to teach after your death. In this case, it's not just then a vehicle for transferring wealth, it's a mission statement. Just like any budget for an organization is a statement of its mission and its values, how you distribute your worldly possessions and wealth is, in many ways, an ethical statement, a soulful statement, perhaps even a religious statement about what you value the most. Now, that also comes into play when you're talking about, if you still have minor children at the time your will is created, who the guardians for your minor children will be. It's not just about, after all, their physical safety and security should you or you and your spouse no longer be living in order to guide them as parents. Who will you choose who is not only capable of meeting their physical needs, but also their emotional needs, their psychosocial needs, their spiritual needs? And yes, when it comes to your faith of origin or the faith you have chosen to bestow upon your children, the opportunity for them to be reared in that community of faith. It's not to suggest that the people you name as guardians for your minor children can't make decisions based on their values as to what is in your minor children's best interest, but they need to be guided by you to whatever extent possible. And of course, conversations well before the possibility of an untimely demise occurs about what you value the most when it comes to the legacy of ethics, spirituality, religion, and more. A will also allows for you to go ahead and to plan for estate taxes. Now, I realize that some of you who are watching will look at this number of 12.06 million per individual, or 24.12 million for married couples, and just chuckle a little bit, because You're never going to make that much. I know I'm not going to make that much. But ultimately, if you happen to find yourself through planning or unusual circumstance to hold an estate that is in excess of those particular values based on your marital status, you do need to go ahead and have a plan for how those estate taxes are going to be taken out of your legacy wealth, and then what is left over is going to be distributed to your chosen recipients. Finally, having an executor or an executrix to manage your estate. I know that both men and women certainly can be described as executors, those who assume that role. I do want to make sure that we use inclusive language, hence the term executrix along with executor. But ultimately, the person's role, executor or executrix, when we say manage your estate, that has everything to do with their ability to go ahead and to either on their own or with the assistance, usually of an attorney, if whether they're an attorney themselves or whether they prefer to rely upon an attorney because they are a layperson when it comes to legal issues. We want to make sure that they are following your stated written wishes with regards to the disposition of your assets, the proper guardianship for your minor children, should that be the case, and also ensuring that the distribution that takes place is done in a timely, fair, equitable manner. Now, having said that, the executor or executrix does not work for free. Depending on the state in which you reside, you may have I believe up to about 5%, and in some states that amount may differ, of the value of your estate, which, by the way, is the first task that the executor is going to be tasked with, or the executrix, is to determine the total value of the estate. That is to say, what is the worth of your not just liquid assets, but also your physical assets that can be liquidated versus whatever debts you may have held, which will not be waived after your death, and working to manage the difference so that proper distribution of the net assets occurs in a fair and equitable way. We're going to talk a little bit more about that in just a moment. Let's talk now for a moment about the requirements for a will. I mentioned in our very first session, on the session of healthcare rights and responsibilities, that medically and legally, there are important questions that need to be resolved when a situation arises in which the legal and or mental capacity, competency, etc., of an individual comes into question. I defined it last time, and I want to define it in greater detail here today. What legal capacity, just to focus in on that and the subsequent bullet points here that you can see, to make sure there's no confusion. To occupy a particular status or relationship with another, for example, spouse, sibling, child. And ultimately, there may also be professional status and relationships with one another. This may be, for example, trustee of a nonprofit organization to which you have signed what is referred to as a bequest, where a part of your estate, all the way up to the entirety of your estate, is being given over to that nonprofit organization after your death. Perhaps you have no spouse or living parents or living siblings, and ultimately you've chosen to give your entire estate over to a nonprofit organization that holds meaning for you. That's one piece of legal capacity. The other piece has to do with engaging in a particular undertaking / transaction. This has to do with the legal aspects of marriage. Again, taking on perhaps a fiduciary relationship in a nonprofit organization, being able to go ahead and to determine how you wish to distribute those items that have financial worth, again, whether they are already liquid or can be made into liquid assets, and thereby going ahead choosing to include people as beneficiaries of one's total worth. Testamentary capacity and testamentary intent. It's important to understand that you have to have the legal / mental ability to make / alter a valid will. So if you were at a point in your life, or a loved one was at a point in their life, where there was no question as to their legal or mental ability to create or to update a valid legal document like a will, terrific. But if, in fact, they have sought to, or they have been asked to by someone in your family circle to update, let alone create a valid will, and they are experiencing cognitive decline, the question regarding their testamentary capacity becomes a very active one and will need to be determined through both medical and legal means. The same applies with regards to testamentary intent, the disposition of their property in contemplation of their death. People are absolutely entitled to change their mind over and over and over again as to how they wish to have their property divided amongst beneficiaries, and to add or delete beneficiaries in contemplation of their death when creating or altering a valid will. But if there is suspicion that they are being coerced to do so because they lack capacity, then the intent is suspect as well. And again, this is where going ahead and having a medical evaluation in anticipation of a legal challenge of their ability to do what they are either choosing to do or being persuaded to do, and whether or not by choice or through persuasion, what they are doing represents the completion of an act based on informed choice. So let's talk a little bit about the formalities surrounding this. The first two bullet points really should go together if you're working with an attorney who knows about creating wills. An attested will, which is written, signed by you or by another person at your direction and in your presence, and this is if physically you lack the ability to sign on your own, attested in your presence by at least 2 credible witnesses over the age of 14. Now, we're not talking about age of legal majority, but what we are talking about is an age that represents a level of maturity in which the average 14-year-old or above can understand what it is that they are witnessing. They don't have to understand the same way a professional has to understand, be they 14 or be they 24 or be they 84. All of the legal tenets that surround the creation for a will. They simply have to understand that you are attempting to in contemplation of your death, going back to testamentary intent, contemplating the disposition of your property. Nothing more, nothing less. And ultimately, these credible witnesses cannot benefit from your will. They're not credible unless they have no vested interest in who benefits from the disposition of your assets. I said that the first and the second bullet points go together. This is an important piece. it is almost pro forma nowadays for, in addition to your will being drafted, what is called a self-proving affidavit being drafted. And this is simply an affirmation that the will was properly signed and witnessed by those credible witnesses who won't benefit from your will, who happen to be over the age of 14. Those details are put into a self-proving affidavit, thereby eliminating the need to track these witnesses down as you go through what is called the probate process. That is the process of making sure that you are legally dead and that you have an executor or executrix properly in place, and that ultimately your will is being I should say the elements of that will with regards to disposition of property are being followed through in a proper fashion, while also making sure to cover debts, if any exist after your death, for which your estate is still responsible for paying. There is the classic category, which you'll see in mystery movies and so forth, called the holographic will. A holographic will, whether it is a will in its entirety or whether it represents an addendum or multiple addenda to an attested will, so long as it is written completely in your own handwriting and signed by you, that holographic will, again, either in its entirety or as an addendum or addenda to an existing will, is considered legally valid. The question of whether or not you possess testamentary capacity and testamentary intent may come up if someone wishes to contest what the contents of the holographic will or addendum or addenda may be. And if so, ideally, that holographic will be determined to be one that you have done of your own free will and understanding the consequences of making a new will or altering a valid will through the holographic method of creation or editing. But again, has to be written completely in your own handwriting and signed by you. So let's talk about probate, demystify it really. Probate, and here we're speaking specifically about probate in the state of Texas, starts with recognizing a person's death and thereby recognizing the need to wind up their estate. That starts, of course, with the death certificate, the medical determination that becomes a legal certification that a person is actually deceased. At that point, the process of winding up the estate can begin in earnest by identifying the estate, gathering all of the assets of that estate, paying out, as I've mentioned previously, any debts that the estate still may owe after your death, and then ultimately doing a distribution of the remaining assets to the stated beneficiaries per your will. There are certain items that are not subject to probate. Again, we're talking about probate in Texas. It very well may be the case if you reside in another state that your state follows this rule, but it doesn't have to. It can be different on a state-by-state level. But in Texas, the following subjects, or following, I should say, properties, are not subject to probate. Insurance policies with named beneficiaries, because again, you've already completed a legal transaction through the signing of that policy. The same applies to bank accounts with named beneficiaries. A procedure has already been concluded. Retirement accounts with named beneficiaries. Any property or assets, and this is an important term of legal art here in Texas, which again may be the same legal term of art if you reside elsewhere. Property and assets that are held in joint tenancy with rights of survivorship. The classic example of this is a joint checking account, a joint savings account, a joint money market account that may be part of an investment portfolio. These are essential in that by not being subject to probate, they follow the timeline that it takes to go ahead and to transfer insurance policies, bank account assets, retirement account assets, property and assets held in joint tenancy with rights of survivorship to the stated beneficiaries as soon as the process allows. Trust assets follow this same rule, and we're going to talk about trusts in just a moment. So ultimately, it's going to be a faster process because you've already taken care of the legal details surrounding each of these financial devices to transfer wealth after death. Independent administration, which is to say, when it comes to probate in Texas, you don't need a bond for executor or for an executrix. And you don't need court permission for that executor or executrix to start taking steps to settle the estate. Once you've got that death certificate in play, that executor or executrix can begin the process that's mentioned above. Identify the estate, gather all assets, pay out debts, and make sure that those assets that are not subject to probate are following the swiftest possible timeline for the transfer of wealth. The other piece about this, when we think about what is subject to probate and what is not subject to probate, is also probate is a matter of public record. This is because if there's perhaps anyone out there to whom you owed money before you died, and the probate process becomes a matter of public record, it gives them the opportunity to say, wait, I have proof of legitimate debts that need to be paid out by the executor or the executrix as they wind up the estate. So it becomes a matter of public record. Now, those other assets that I mentioned that are not subject to probate are not a matter of public record. And ultimately, your privacy, it's not a case here of trying to duck debts, but ultimately, it is an opportunity to go ahead and to make sure that the general public doesn't need to know what your financial worth at death was. But again, the public record piece does serve a purpose because in case there is someone out there to whom you owed money before you died, and they can prove that it is legitimate death that does not get waived after your death, they can go to the executor, the executrix, and make sure that the paying out of debts includes what they are owed as well. So let's talk a little bit about trusts, which, as I mentioned in the previous slide, fall into the category of things that do not get entangled with the probate process. A revocable living trust, which again, any attorney who is working with you on your will and your self-proving affidavit for the witnesses to your will, to avoid having to track them down later, what is the purpose? Well, the purpose is primarily to use your assets during your lifetime and to securely transfer them to your beneficiaries after your death using a similar streamlined process that the transfer of insurance policies and other bank statements and other retirement accounts and so forth have already had in place or have been put in place, and therefore don't need to be repeated through a probate process. The trustee can be you or your spouse to manage during the lifetime of the revocable trust, and it can be changed whenever you wish. Irrevocable trusts, by their very nature, the name says it all, cannot be changed. There are advantages and disadvantages to that go beyond the scope of today's conversation, but I would certainly encourage you to speak to an attorney about the difference between and the up and downsides of having an irrevocable trust versus a revocable living trust. As I mentioned, a revocable living trust falls into the category of assets that, because a legal arrangement has already been created, they avoid the probate process and therefore are kept out of the public record. If you are incapacitated, it avoids the need for what is referred to as conservatorship proceedings. One step below, say, guardianship of your person. In other words, making decisions about your life, your medical care, etc. A conservatorship has to do specifically with about financial transactions, the paying of bills, the maintenance of investments, and more. If another trustee or co-trustee can come into play because they have been named as secondary or tertiary trustee, depending on how you've chosen to assign trustee members in your family, you don't need to go through the process of having a conservator assigned to you to take on that role of financial management, because another trustee is going to do it for you. This next piece is important to note. A revocable living trust is not a magic shield from protecting your assets from other creditors, or very often when we're talking about aging, and not necessarily aging in place, but making use of a Medicaid benefit to go ahead and to utilize the services of a nursing facility. There is a spend down requirement that we will talk about in the third and fourth parts of Aging with Grace, about how one qualifies not only medically, but also financially in order to use their monthly applied income as well as a Medicaid benefit that they now are qualified for to cover their stay in a nursing facility. Until that financial qualification is met through a spend down process by paying out of pocket to a nursing facility, you won't qualify financially for Medicaid. But once you do, of course, at that point, you are able to go ahead and to rely upon your monthly income. We're talking Social Security and so forth, and the Medicaid benefit to keep you financially in place so long as you continue to medically qualify for nursing facility care. Having said that, and we'll talk about this in subsequent units, the Medicaid Estate Recovery Program, known as MERP, is alive and well in the state of Texas, which is to say, there is a right that the state has to try and to recover what it invested in your care while you remained alive and living in a nursing facility after reaching the state of financial qualification, not just medical qualification for residing there. A taste of what's to come. So if you have questions about that, let's hold on to those until we get to the third and fourth units of the Aging with Grace series. A revocable living trust can't just be an empty shell. It has to have a transfer of at least some of your assets into the trust. And there needs to be, even if you don't have a traditional will yet, I hope, there needs to be what is referred to as a pour over will, which is to say assets not included in the trust. Think of it as if just about everything in your estate falls into, and I'm going to skip back a slide just to say, to highlight those areas not subject pardon me there, not subject to probate. Let's say that 90% of what you own falls into this category of insurance policies, bank accounts, retirement accounts, property and assets, hold in joint tenancy, trust assets, as I've mentioned. But you still have other physical items that perhaps never made it into any of these categories. You might have a bank account that never made it into the category of having a named beneficiary. This is where that pour over will piece for assets not included in the trust is going to be necessary. It is going to go through probate. And whether you have an actual will that includes all of that, or whether you have the pour over will, just recognize that the probate process is going to touch your estate in at least some small part, but it does not have to paralyze the transfer of wealth to your beneficiaries if what you have falls into those categories of financial vehicles, like the trust and everything else I've mentioned, that is exempt from the probate process. What other documents do I need as I prepare for the fact that I am mortal? Well, ultimately, when we talk about powers of attorney, we are referring to both durable power of attorney for business issues. If you become incapacitated, this is going to require, and I certainly recommend that you do it with an attorney, but it is going to require, however it is created, a notary to go ahead and to stamp their witnessing of your signature on who you have assigned, whether it is one person, whether it is someone as primary or secondary or tertiary. Durable power of attorney, all business, financial related issues. If you become incapacitated, that person will take on the responsibility, or if the primary can't, the secondary will step in, or the tertiary will step in for primary and secondary durable powers of attorney to make sure that all of your bills are paid. If you are operating a business, that the appropriate steps are taken to maintain or to liquidate said business, etc. Then there is medical power of attorney. Again, can be one individual, can be a primary, can be a secondary, could even be a tertiary. Ultimately, when you go ahead and draft the details of a medical power of attorney with, by the way, a HIPAA release. As I mentioned last time, HIPAA stands for the Health Insurance Portability and Accountability Act. And this is crucial because ultimately, whoever is tasked with following to the best of their ability your wishes regarding medical care has to be able to be consulted by the people who are tasked with your care about what medical issues you are facing and the choices that lay before you. Ultimately, two qualified witnesses, again, adults, in this case, it has to be legal adults, 18 or above, who are non-relations and won't benefit from anything related to what is being signed in this medical power of attorney, which is to say, an employee of a hospital is typically not used unless there is no other option available to be a witness for your signed medical power of attorney, or two witnesses, because ultimately you do need two. I would suggest that if you're in a situation where you need a medical power of attorney with a HIPAA release signed, and you have no qualified witnesses, again, adult non-relatives, and you're worried about whether or not employees can or should be qualified witnesses, take the time to bring a notary to your bedside, wherever you happen to be. There are notaries who travel, and have them go ahead and affix their seal after witnessing your signature. If you choose not to have a medical power of attorney, or you just don't get around to it and are hit by a bus, know that there is a decision order by default. And in the state of Texas, that decision order currently is spouse, adult children, parents, siblings, and then I say other relatives. The statute says ultimately the closest living relative. And they're not talking just about closeness in terms of first cousins versus second cousins. They're talking about who's reachable and who's willing to go ahead and to speak on your behalf if you cannot speak for yourself. A directive to physicians and family or surrogates, what is known as a living will. This is something we discussed in our previous session. So by all means, go to the recording, and I know this is a popular, frequently asked question. All the recordings for the series, all the slides for the series, they're going to go your way for registrants to Aging with Grace after the series is completed. But we also have recordings of the last incarnation of Aging with Grace on the resources tab of the Hope and Healing Center's website, hhci.org. So if you need it in a hurry, you can always go there for the recording, and you'll see, of course, the slideshow as well. This is ultimately your living will, which again, two qualified witnesses, given what I've described before, or a notary, are required to go ahead and to sign off on, explaining your wishes regarding end-of-life issues. And another document that we touched on last week, the out-of-hospital do not resuscitate order, or out-of-hospital DNR. In addition to the two qualified witnesses or the notary affixing their seal after you sign, you need a doctor's signature for this as well. Whether it's your primary care physician, whether it is someone who is serving you in the hospital, irrespective of who that doctor is, you need a medical professional, a doctor's signature for an out-of-hospital DNR if you are inclined to have one in place. As I mentioned last week, tattooing and a DNR on your chest isn't good enough. If someone panics, you're in distress, emergency services come to your bedside, and they don't have a document that says you are not required to engage in full life-saving measures. Otherwise, they have to default to it. That's their job. So the out-of-hospital DNR is something that gives first responders, anyone outside of a hospital, permission to refrain from heroic life-saving attempts. This usually applies when you are nearing end of life, or you have reached the point where you have decided, say, after living with a terminal diagnosis for which the prognosis is 6 months or less, to add an out-of-hospital DNR to the essential documents that are perhaps hanging in front of or above your bed, on your refrigerator, someplace prominent, as you work with those skilled in what is referred to as palliative care. Very often, the services of a hospice company will be the vehicle for palliative care measures. Again, something we referred to in last week's presentation, and which you will have access to either through our resources tab or sent directly to you after the end of this series. So I want to wrap up with, and normally I would just flash resources on the screen and say, go check these out if you would like more information. Today, I want to point out a couple of things. Just because we list attorneys here doesn't mean that they are the right match for you. You are going to need to go ahead and do the legwork, whether you take the names of people we have added to this resource slide because we have worked with them in the past and found them to be honorable practitioners who are knowledgeable in the field of elder law, estate planning, and more. You also have, beyond the named options who are here, the option of consulting the Houston Bar Association's Elder Law Services Division. You can also go ahead and review through what is called texaslawhelp.org, a resource I highly recommend for a cornucopia of legal issues, their elder law handbook that happens to have been created also by the Houston Bar Association. And recognize that if finances are a barrier to service, that we have an amazing clinic that is run through the University of Houston's Law Center, and that you can sign up for consultation there. It's not that the HBA, the Houston Bar Association's Elder Law Services Division, it isn't useful. You may very well find practitioners they recommend who are willing to work at sliding scale, or even what is referred to as pro bono, that is, under the legal obligation to offer a portion of their services at no cost to the population in our society that is going to take the greatest financial hit by utilizing legal services. So when all is said and done, what we want to do is to make sure that you recognize we are not telling you go to these people specifically and no one else. We simply want to give you a starting place for making sure that you have ample resources as well as able practitioners who you can consult with, whether you decide to ultimately utilize their services or move on to someone else. With that, I'm going to go ahead and put up, again, our contact information. Remember that if at any point in time you have questions or concerns that go that stem from, I should say, the material that's been shared with you in any of these Aging with Grace sessions, or you just want to get into more detail about the elements of what makes CARES cares: caregiving, aging, resilience, ethics, spirituality. We encourage you to go ahead and to reach out to either or both Dr. Dettermeyer and or myself for any consultation that we can assist in when it comes to, and here when it comes to legal issues, it really does mean passing you along or educating you to the point where you are comfortable accessing legal services. When it comes to the other aspects of Aging with Grace, we will also make referrals, but in the case of healthcare rights and responsibilities, of finding an appropriate home setting, whether it is your own home, independent living, long-term care, paying for aging, making sure that we refer you to the appropriate professional disciplines and practitioners in those disciplines. And of course, as trained chaplains, as well as specialists in Dr. Dettermeyer's case in bioethics, in my case, not just in community aging, but also in long-term care regulation, we want to go ahead and give you the benefit of our earned knowledge as well. With that, I'm going to go ahead and I'm going to just do a quick check of after I stop sharing, and notice that my screen went to purple today. So apologies for that. But I would like to just check and see. I don't see any particular questions coming out of the chat. So since we're close to the hour, I'm going to go ahead and wish everybody a fantastic week and encourage you to reach out to us. And if you didn't happen to catch all the information from that last slide, all you need to do again is to go to our website, hhci.org. in order to reach out to us and ultimately to schedule consultations as desired. I hope again that it is a good week, a meaningful week. We're going to see you in 2 weeks. Remember, we're skipping next week. I will be unavailable. After that, we will move into session 3 on October 2nd and session 4 on October 9th. All the slide decks and recordings are going to be available to everyone after the series is over. And again, if you want to look at archived recordings of the spring 2023 version of Aging with Grace, just go to our website, hhci.org, and click on the resource tab. And again, you will get the slide decks and the recordings from the fall 2023 session when we've completed the series on October 9th. Blessings to all. You take care.